I guess when the person wearing the referee's jersey already told the crowd who he wants to win before the game even starts, you have to wonder why we're still playing. Hey Canada, it's Earl.
You've heard the big news coming out of the Supreme Court, but the mainstream media is treating it like a footnote. We're talking about Chief Justice Richard Wagner, the top judge in the land, refusing to recuse himself from a case involving the Emergencies Act. Now, for those who don't know, recusing yourself just means stepping aside because you might be biased. And boy, does the Chief Justice have some history here. Back in 2022, while the dust was still settling on the streets of Ottawa, Chief Justice Wagner didn't wait for a courtroom to give his opinion. He gave an interview to Le Devoir where he called the Freedom Convoy protests the beginning of anarchy and claimed that hostages were taken. Now, imagine you're a Canadian citizen going to court to defend your civil liberties, and the guy sitting in the big chair has already labeled your movement anarchist in the newspaper.
Does that sound like a fair shake to you? Because to most reasonable Canadians, it sounds like the verdict was written before the first witness was even called.
The media loves to frame the Emergencies Act as a necessary evil, but let's look at what the actual courts found, not once, but twice. Justice Richard Mosley, who admitted he started the case leaning toward the government, looked at the actual facts and ruled that the invocation was unjustified and unconstitutional.
The court found that the government's actions violated the Charter of Rights and Freedoms, specifically the right to be free from unreasonable search and seizure when they froze bank accounts without a warrant.
The Conservatives have been shouting from the rooftops about accountability, and for good reason. When a judge publicly weighs in against a group of people, the appearance of impartiality is gone. If the Chief Justice has already called the protests anarchy, how can he objectively decide if the emergency was real? In Canadian law, it's not just about actual bias. It's about the reasonable apprehension of bias. If a regular person on the street looks at his comments and thinks, yeah, he's already made up his mind, then he shouldn't be on the case. Period. This isn't just about one protest. It's about the precedent. If the government can break the law, ignore the Constitution, and then have the Chief Justice, who already cheered them on in the press, oversee the appeal, then the rule of law in Canada is officially on life support. The Liberals want you to think this is about safety and order, but it's really about control. They want a judiciary that acts as a rubber stamp for the PMO. But we remember the rulings. We remember the words. And we know that no matter how many values books they write, the law is supposed to apply to the people in the fancy suits just as much as it applies to you. The referees are picking sides, Canada. It's time to start paying very close attention to who's calling the plays. Thanks for watching. Stay awake.